Hello, this is Rick Durfee from Durfee Law Group and Estate Planning Law Group. We're happy to be here. It's exciting.
Glad to be here. It's Michael Koberline coming from Durfee Law Group, and also wanted to do a shout out for Grand Canyon Title and Bliss Realty. Glad to be here with you guys.
We're excited for today's topic. We're going to be looking at estate planning kind of as an overview, kind of a 60,000 foot look at estate planning. And we have some fun things to talk about. I think it's going to be really helpful for both advisors that might be wanting to help their clients get estate planning, as well as individuals who are thinking, well, do I need an estate plan? Is this something that affects me?
Yeah, and for most everyone, advisors, if you're just a regular consumer looking for these types of services, a lot of people will ask themselves, okay, I've heard about estate planning, or at least I've heard that phrase. I'm not really sure what it is. So what is estate planning, and why should I even care that I have it? So if we could talk about that briefly.
Sure. So estate planning is part of a family of related kind of planning. There's retirement planning, long-term care planning, succession planning for businesses, and charitable planning and business planning. And all of those plans relate to and are connected with estate planning. And estate planning is typically funding and paying for the taxes when we die. So there's tax considerations, whether or not we have a probate, who's going to get our stuff when we're done with it, and what effect is it going to have on them. And something that is often overlooked is that estate planning is more than just what happens when we die. In fact, this is one of the ways I like to distinguish between garden variety, ordinary estate planning, and dynasty estate planning. We can look at our estate plan and we can contemplate, well, if I do this, what is going to be the long-term effect? And we can help, we can't really govern from the grave, but we can influence the long-term consequences of wealth transition and have that be more of a positive thing and less of a negative thing. So estate planning is kind of related to all those things, and it specifically addresses, from our perspective as the lawyers, the legal documents that you need. And so we'll kind of go over some of that as we go.
Okay.
One of the things I want to point out is that a lot of times people don't know if they need estate planning. In fact, a colleague of mine was recently at an event where there were a number of extremely wealthy people, and there was a pretty young man there, who's in his 30s, I believe, who had recently sold a tech company, and net to him after taxes and everything, he had several $100 million. And he was hearing about some estate planning and kind of in disbelief, he goes, wait, do I need a trust? I'm poor. I don't have that much money. And I guess he was thinking that to need a trust or to need to do estate planning, you had to have, I don't know, more than several $100 million. And that's often something we see, is that people think, well, estate planning is for someone who has more than I do, whatever that is. I only have this much and I'm poor. And if I only had more, then I would need estate planning. And the actual threshold for estate planning is much lower than people believe. And in fact, let me kind of give you an example. A young family, a man and a woman with maybe one or two children that are little, and they have student debt, so and very few assets. So if they did a balance sheet to get a loan at a bank, they would actually be negative. They're insolvent. They're upside down on everything. But they're trying to be good parents, and they're trying to plan for the future. So they went out and they bought a life insurance policy on the breadwinner, which whoever that might be. It might be both of them, but they bought life insurance. And now we have to ask this question: what's going to happen if the event that they have purchased insurance to protect them from happens? The breadwinner dies, and there's a payment on a life insurance policy, and there are little children. Is the insurance company going to write a check to the little children? And the answer is no way. It is not going to happen. Who's going to get the money? Well, somebody is going to get the money on behalf of the children. And if there is no estate plan in place, then the family members are going to have to go to court to decide several things. They're going to have to go to court to decide who's going to get custody of the children. They're going to have a judge decide who's going to get the money. And then they're going to have to account to that court every year until the children turn age 18. And then these children that have grown up having suffered a traumatic event in their childhood and lost their parents and grew up without the benefit of their parental influence are, at age 18, are just going to get all the money. There it is. The judge is going to lean over the bench and say, hey, kids, you want the money? And they're going to say, yeah. And then they get it. And so what's going to happen to the money? It's going to be gone. So there's a young family and they're thinking, we're broke. We're upside down. We don't need an estate plan. They do need an estate plan. So they need some very basic documents at a minimum, and maybe even a trust. So the threshold for needing an estate plan is much lower than a lot of people think. There are other thresholds like the probate threshold. If in most states, if your assets are over $75,000 is kind of a typical number. It varies some from place to place. But if you have assets over $75,000, your estate would be subject to probate. And then, well, what about estate taxes? And currently the federal exclusion, this is going to instantly date this video. In 2020, when we're doing this, the estate tax exclusion on a federal level is $11.5 million and change per person. So 23 million and change for a married couple. But there are a number of states that have state estate taxes. And certainly outside the US, there are other countries that have, even if they don't call them estate taxes, they have other kinds of taxes. And we're dealing with an estate right now in another country. The person lived here and was domiciled in the US, was a US citizen, but owned property outside the US. And there are taxes on that property because the individual died. So there are many, many considerations for that. So tax considerations, probate considerations, where the property's at, where the family's at, what's going on in their lives.
Yeah, I think the what's going on in their lives is a big part of the planning side of it. I like the example you gave of the young family that's just starting out and may not be solvent. You have, people too who are just single and they just reach adulthood and their 18th birthday gift might be a, medical and financial power of attorney and living will and a will if you want to do it right to start out for those adult children as well.
Right. Thank you for bringing that up. It's a great point. Who needs those basic legal documents, the medical power of attorney, durable general power of attorney, financial power of attorney? And the answer is anybody over the age of 18, with or without assets. And in today's world, we have a significant, a growing number demographically of individuals who are adults, but they're not married. They may or may not have children, and they're living wild and free, and which is more power to them. But what happens if there's a medical event, if there's a car accident or some other kind of event that doesn't kill them, but they're incapacitated? Who's going to make the decisions? And mom and dad think, oh, I can make the decision for my 26-year-old single adult child. And no, you can't. You have to go to court and get a court order unless they have done some estate planning, putting documents in place in advance that designate decision makers for those various situations. So even the 18-year-old that's dead broke and doing whatever they're doing. So just in my own family, when my children become adults and turn age 18, that's something we've done. They all get those basic documents, and we encourage our clients to do that. You have adult children, your adult children need something, and whether they come to us or go to somebody else, help them do something so that they're not stuck. And I guess I was impacted by this years ago when I was barely starting out in this arena. I was representing a group of business owners that there were 3 different owners that owned this business together, and the youngest among them was actually the spark plug. He was the guy, it was his idea. He had assembled the group, he had put it together, and he was in his early 20s, single, and he'd started this company. And after we had done some planning, unfortunately we had done planning, he had a motorcycle accident, and he was not dead, but he was completely incapacitated, both physically and mentally. Frankly, he could not run the business. And so for the business, we had buy-sell planning in place. His partners were able to buy him out. The proceeds of the sale, he had insurance in place that has been taking care of him. He's still alive, actually, now several decades later. But because of the planning in that situation, the business was able to continue without its founder and thrive, and still thrives. And the founder, who had had this terrible event happen in his life, was able to have the financial care he needed, and his parents are making decisions for him because he's in a facility, in a care home, because he can't care for himself. So all kinds of situations where estate planning is really, really critical, even though we might think, well, I don't have kids. I'm not leaving money to anybody. Why should I care? I'll be dead. Well, what happens if you're not dead? Then there's planning that needs to be done.
Yeah, I think that a lot of people and I like what you're talking about, and we sometimes refer to it as integrated planning, where everything comes together, whether it's personal things or business or whatever. Whether we try to prevent any gaps in the planning. And I think a lot of people appreciate that. They want something that's seamless, that they can rely on and have peace of mind, and that's the kind of thing that we provide. I'm not always sure that, like you're saying, sometimes people don't necessarily know what they need. So if you're somebody who's watching and you have that question, you're an advisor, and you need to know the right questions to ask in order to get the information needed to start people down the estate planning road. How do you facilitate that?
So we have several tools that I'll mention. One, we have a free publication called "Do I Need a Trust?" And there's several pages of questions, and the more yeses you click on in answer to the questions, the more you need a trust. And some people, I guess it's theoretically possible. In fact, it is absolutely possible that somebody could go through the list and it's all no's, and then they don't need a trust. And candidly, there are alternatives to a trust. But something like that is a good place to start. That's an indicator of, well, I at least need that. But here's my first question. Are you over the age of 18? Are you living and breathing? Well, then there's a certain level of estate planning you need. And that's for the consumer. For the advisor, for the real estate advisor or the banker or the financial service provider or the insurance person or the I don't know, just the smart lady on the corner who knows everything and tells her neighbors how to run their lives. We all know those people and we love them, and they're actually we call them up when we say, hey, I need somebody that can do this, and they'll go, oh yeah, I know somebody who can do that. So what do they need to know? Well, they need to know that people need this stuff, and they need to know that there are resources that can help them. And there today, in today's world, you can find out anything by going online. So I would encourage people to go check out our website, check out other websites, become educated, go to seminars and meetings, get some books and read things. But also, sooner or later, it's going to be to everyone's advantage, whether you're the consumer or the advisor who's helping consumers. Consult with a lawyer who knows what they're doing and who has some experience in this area, and get some good, solid legal advice. And I want to point out something here with lawyers. Like all professions, whether they call it this or not, lawyers become specialized. They have a niche that they work in. And for example, there's some things we do very well, and there's some things we are terrible at. Do not hire us for things that we don't do. But there are things that we do and we're good at. And so it's appropriate when you go to talk to a lawyer about estate planning that you find one that actually knows what they're doing. There are lawyers that I call them dabblers. They do a jillion things, and every year they'll do 2 or 3 estate plans. And that's not bad. And especially the country lawyer, if they're in a small community and that's all they're serving is that community, that's not necessarily bad. But the lawyer who does 2 or 3 or half a dozen plans a year is going to have a different perspective, a different set of tools, a different experience and a different knowledge base than the lawyer who does hundreds of estate plans and that's all they do. And so find an advisor that's appropriate for your situation. And sometimes the simple, easy little thing is fine, but sometimes it's just not. I think for the advisors, one thing that's important, if you're an advisor in any capacity, in any field, you want to be someone that your clients look to as a source of answers. Hey, do I need this? And if I do, can you help me? And so I think the advisor's role is to be like a concierge. Oh yeah, I have tickets, here you go. Or no, I don't have tickets, but I know a guy, let's call somebody. And we feel the same way. If you call and ask us an investment question or an insurance question or a real estate question or a title question, there's a whole lot of that we don't do, but we know people who do that. And that's why, our co-hosts with this meeting, the title company and the real estate professionals we work with are a great benefit to our clients because, we don't do that, but we know somebody who does. So we want to be on the list of people that who do this.
And as a part of that, I would say, when you look at an estate planning law firm that has a niche in dynasty planning, like we do, you may not always, as an outsider, think that we do things like forming new businesses or buying and selling real estate or not buying and selling, but assisting in the process of buying and selling real estate and businesses. But, we do that and we do a lot of it and we do it really well. So that's important, I think, for anybody watching to know that when you do see an estate planning firm on its face, it may not always necessarily tell everything just from the estate planning title. But certainly we do a lot of other things. And the reason for that is because we just have a lot of clients who do a lot of that do a lot of those types of transactions. And so we become very good at doing that over the years.
Well, also, candidly, estate planning is a multidisciplinary area of the law. It necessarily involves not just wills and trusts, but property real estate law. It involves marital property rights. It involves family law. It involves charitable planning and tax planning and business planning. So to be effective as an estate planner, we have to be schooled in those other areas. And in fact, especially in dynasty estate planning, which is estate planning that looks beyond the moment of death and who's going to get our property to how can we structure this so that long term it's going to grow and be protected and benefit the family and minimize the taxes and on and on. To be able to do that, we have to use business devices. We have to recognize that our clients are going to own real estate, and we have to know what to do with the real estate. And when is there something we can do, and when do we need to call an outside professional? So estate planning is by its nature multidisciplinary. And I guess this is something also that distinguishes. There are estate planners who all they do are wills and trusts. And if you need a business entity, they can't help you. And we actually love those kind of estate planners for this simple reason. We'll collaborate with them. We'll help them. We have a number of people who do that level of estate planning who, when their clients need business planning or charitable planning or asset protection or multi-generational planning, they'll say, yeah, I've done the basic estate planning. Can you help them with this other stuff? And so we work with even other estate planners who do that. We have actually a network of other attorneys around the country that we work with that they've done the basic estate planning and we're doing all the other stuff. I guess what might be called the advanced planning or the dynasty planning.
Well said. I agree. And I've also seen that's one of the things that sets us apart from maybe some other estate planning offices is that we, as you mentioned, and I like the way you put that, a multidisciplinary approach to estate planning. And as part of that, I've also seen this as one of the things that sets us apart, that we provide a drawn diagram that is customized and gives our clients a snapshot or a picture of all of their stuff on one sheet of paper, so that they can get a good idea of where they're at with their assets and things. So can you talk a little bit about the evolution of the diagram?
Yeah, I love our diagram. It's become a powerful tool, and I wish I could take credit for its origins. I actually worked with another lawyer who's long since passed away. He was one of my early mentors and became my partner. I became his partner for a number of years. But we were working at the time with a large family that had extensive business holdings in more than one country, in more than one place, and the family was complicated. There were children from multiple marriages, and it was a big, diverse family. And we were taking notes on a yellow legal pad, and it was, frankly, we were getting overwhelmed, and we said, wait, let's draw a picture. So we pulled in a whiteboard and we started drawing a picture. Tell us, okay, who are the family members and how are they related? And we mapped that out. Okay, what are the business entities? And we mapped it out, and we mapped who owned what in the business entities. And the family had never done that. So everybody knew a little piece, but nobody knew all of the pieces. And by putting it on the diagram, everybody understood more, and we uncovered gaps and overlaps in their planning. And from that, in the early years, we always did it by hand. Today, if we're just starting out in an initial meeting, we might draw that by hand because we're taking notes. But now for all of our clients, we create a custom colored diagram that maps out the family members, the business entities, the trusts, the assets, and what their status is, how it's owned, what has been done, what needs to be done, we're thinking about it, but we haven't decided yet. And we can share that diagram not only with the client and their client's family members, but with their CPA, with their financial advisor, with their insurance people. And it becomes a tremendously powerful tool. And even with simple plans where all it is the powers of attorney and wills and a trust, it helps the client visualize, oh, my trust. In fact, this morning I answered an email from someone who said, where should I own this? And in my email response, I said, look at your diagram. You'll note that on the diagram, there's a little tag right here that says this. And we flagged on the diagram where things should be owned and what things are already there. In fact, the client said, do I need to deed my house to the trust? And we said, yeah, we took care of that for you. It's already done. You'll see the little green check mark on the diagram with the date beside it. That indicates that it was done. So it's also a great way to track what is done and what's not done. We use that diagram extensively. If a client calls in or emails us, we'll pull up that diagram. We take notes on the diagram. With clients that have been with us for a long time, we'll have a history of diagrams that will in effect be our notes and the cumulative changes that have occurred over time as they've added this or changed that. And by the way, I've had that be tremendously valuable when someone passes away or there's a succession or a transition event, and they're saying, well, how did we get here? And we can look at that series of diagrams and see, okay, over the past decades, this changed, then this changed, then this changed, and we can piece together that history. So both as a planning tool, as an educational tool, as a device to understand it. In my own life, in my own family, I have a copy of my diagram pinned to a bulletin board in my office. My wife has one taped to the inside cupboard door of her office at home so that we know, oh, this is over here and we need something over there, and how do we make this work and how does it relate? It also, let me mention this too. Estate planning has a consequence on generation 2 and 3, and people like to pretend that if we don't tell our children anything about what we're doing, we can prevent them from having problems with what we're doing, and that's just the opposite is true. Generation 2 and 3 and 4 needs to be educated, and they need to be informed, and they need to know what mom and dad were doing and why they did it and what's expected of them as part of the process. And that diagram is a fantastic tool for integrating generation 2 and 3. More than once, we've had family council. In fact, we generally have a family council annually specifically about this, where we pull out the diagram, and there have been changes from last year. What's changed? What's new? Our children are adults now and are married and have their own plans and their own businesses and their own deals. And we look at that. And as a family, we work together to help each other. How are mom and dad going to help the kids? How are the children going to help each other? How are we preparing generation 3? And that diagram just becomes a point of reference. We can see how the pieces fit together. So I love the diagram, and that's something I'm really pleased with, and see tremendous benefits. And that's something, by the way, I've had people come to me. This has been a consequence of speaking nationally. They'll see my diagram and they'll say, "Yeah, I've done all my estate planning. I don't need you to do anything, but I want you to make me a diagram." And especially in a big, complicated estate, it takes a lot of time. I've had people pay tens of thousands of dollars just to get a diagram that's customized, that shows their stuff in a detailed fashion, so that they know what's going on with their estate. So it's a very powerful tool. Thank you for asking that question. I like that question.
Yeah, no, I agree. I think it's interesting how something, it's quite simple, but I kept hearing you say valuable and value as you described almost every situation that we use the diagram in. So it's a simple tool with tremendous value. And the way that I've seen it really help is when, a client calls and maybe it's a case that I haven't necessarily worked on, but I need to get up to speed quickly. The diagram really helps with that as well, to kind of orient and then be able to answer questions without having to know all the history of the client, because it's right there in one snapshot, and you can usually get a pretty good idea of where they're at and the answer to their question. So that's been one way that it's been valuable for me, and I think it would be valuable for other advisors as well in that way.
I recently had an experience. A client called that I had not heard from for several years, and they had a question. And as we were talking, I asked them, "So how's your daughter in this place where she's living? And what's going on with this?" And the client was flabbergasted. They said, "How do you know that? How do you remember this?" And I said, "Well, candidly, I couldn't even remember who you are, because between here and when we last met, I've had so many people come through my office. I did not remember you at all, but I had a diagram. I pulled it up, and as soon as I saw the diagram, then I remembered. I go, oh yeah. Oh, and I had notes on the diagram about all these things, so I could ask the questions. So yeah, it's really a good tool. In fact, I'll mention this too. I've had people say, "Oh, my estate planning's done. I'm completely done." I go, okay, great. And just by hand, let's diagram that out. What do you have? Okay, I have a trust. Okay. What businesses do you have? Notice all these businesses and these properties. And then who owns what? Who owns this? And they'll, after telling me their estate plan's all done, we'll find out, oh yeah, I have all this real estate. It's not in the trust. I have all these business entities and they're not in the trust. And I have deals with people that are undocumented. I have loans that are on a handshake. There's no documentation. So that diagram is a good fact finder. People all the time say, what do you need as a fact finder to start estate planning? And we begin with that diagram, and we're going to map out family members. Are your parents living, or are your parents gone? So if they're living, are you likely to receive an inheritance? And if you receive an inheritance, what's that going to do to you financially? And people say, well, I'm not counting that. I don't base my life on that. Yeah, we get it. And you're not counting it, but the IRS is. And so we need to plan to approach it properly so that you get it instead of the tax man. So we'll diagram the family members. We'll diagram facts like birthdays and who's related to who. And if there's children from more than one marriage, whose children are whose. And how do we want to address that in terms of dividing up things? So even with just fact finding, that's important. And this kind of draws another issue as well. a lot of times people, in fact, when we strip away what are people really concerned about in estate planning, and they'll say, oh yeah, I want to avoid probate, or I don't want to pay taxes, and that's true. But when we talk to people and we get to know them, and we develop a relationship of trust, and they're to the point where they can truly confide in us, this is what we find. That more than the money issue, more than the tax issues, more than the I want my estate to be simple and easy issues, people are concerned about the people they love. They love their children and their grandchildren and their spouse and their parents and on, and they want their family to work. They want there to be happy, healthy, positive relationships. They want to avoid conflict and fights. They want, when they are leaving wealth to family members, they want it to have a beneficial impact on their lives. They want it to be a good thing, not a bad thing. They all know neighbors that, or friends or family members, so-and-so inherited money and it messed up their marriage, and they had a substance abuse problem and it destroyed their life. And so for some reason, being a trust baby is a bad thing. Oh, you inherited money in a trust. And it's kind of almost a cultural, iconic stereotype that people in that situation are messed up. And there's some high profile, very public cases where that's pretty obvious that that's happened. So how do we transition our wealth and our assets from one generation to the next and not mess up the family, not destroy what matters most with these material, worldly concerns? And that's something that we really like to address. And there are tools that help with that. Legal tools alone can't do the job, but legal tools along with family culture and with certain behaviors from parent to child and in business and estate planning practices can really help with whether or not the wealth that we leave the next generation is going to be a blessing or a curse. So people, if you're out there wondering, well, wow, listening to this, I probably ought to do something, either personally, or I know I have a client that really needs some estate planning. Here's a clue. And in fact, my mentor that I learned how to do the diagrams from, he would always say this to me. He would say, Rick, you can create any reality in the world that you want by putting something on your calendar. And what he meant was, okay, if there's something we need to do, schedule it. Most of us, we tend to show up for our appointments and our commitments. So if we're thinking, wow, I need to do some estate planning, get something on your calendar. Whether it's schedule a personal planning meeting with you and your spouse, or you and your children, or you and your financial advisor, or you and your real estate advisor, or you and your attorney, you and us. Schedule something, get it on your calendar. And then when you go to that commitment, that appointment, whatever it is, then you can begin to address these issues. We find we offer a complimentary initial meeting, and people come to that meeting with very different levels of preparation. Some people have thought through, yeah, I know exactly where I want my stuff to go and who's going to get my minor children and who's going to make my medical decisions. And other people, it's a completely new idea for them. They recognize, oh yeah, this is important, but wow, I haven't given this serious thought yet. So wherever you are in that process, putting something on your calendar can help you get to the next step. And if you get to the next step, then you're one step closer to putting something in place. There's another myth that people struggle with, or that becomes an issue, is that people think that, oh, once I've done my estate planning, I've got one, I'm done. And that's kind of like thinking, well, I worked out once, I ate a good meal once, I'm healthy, I took a shower once, I'm clean. Sadly, this is not I've done it once, I'm finished forever kind of situation. That's, oh, I put gas in my car once, I can now drive. It's something that requires ongoing maintenance, some attention from time to time. So something we encourage everyone to do, even if you have an estate plan, even if you're one of our clients, in fact, especially if you're one of our clients, and putting something on your calendar, you should have at least once a year a time when you sit down and you look at what have you got, what's in place. Is it still right for you? Have things changed? If you have a trust, is it doing what you want? Do you have the trustees that you want? Does it own your property? If you don't have a trust, well, who owns your real estate? Who owns your business? If you have wills, well, wow, we did these wills 20 years ago when our children were little, and now they're all adults, and there's stuff in there that just doesn't apply anymore. If you have powers of attorney, you go, oh, wow, I have people named in my powers of attorney that are dead or that have moved out. Clearly, there comes a time when those need to be updated. And so everybody should look at whatever they have at least once a year. And well, when do I need to go have it reviewed or get advice from a professional like attorneys? And the answer to that, the rough rule of thumb, and there's obviously variation to this, but the rough rule of thumb is 5 years. Every 5 years, you should come in, see a lawyer, get a review, and that's something we offer. Those 5-year review meetings. We put a time limit on it. You can't go for 9 hours, but those review meetings are complimentary. Come on in. If it's been 5 years, let's look at it. And there are times, in fact, we just had this happen last month, where we say, yeah, it's been 5 years, but your family's exactly the same. Your finances, they've gone up a little bit, but they haven't really changed. Your property's the same. We could update these documents, but why don't you go for 2 more years? Let's get a couple more miles out of these tires before we replace them. Go for 2 more years, and we'll update these in 2 years, because they had an event that was going to happen in 2 years. Okay, in 2 years we're retiring. Okay, well, let's go that far. When you retire, as part of the retirement plan or process, we'll update these documents then. There are other times when we go, yeah, these documents, they're only 2 years old. They're not 5 years old, but mom died. Your daughter got married. You love her husband more than you love her. Whatever, things have changed in your life. You have new grandkids. There's been enough changes that, yeah, we need to make some updates here, even though it hasn't been 5 years yet. So put those review meetings on your calendar. If you have a plan, if you don't have a plan, put a let's get started meeting on your calendar. Other questions people ask, well, I can go online. I can find forms. I'm a smart person. I can dig around and find free forms. In fact, there are some forms that state governments will give you. They'll give you, there's medical directives and powers of attorney that a lot of state agencies will post online. You can get it for free. Or if you go to a medical facility, they'll ask you, do you have a living will and a medical power of attorney? And if you say no, they'll give you one for free. Why don't we just use those? And sometimes there are certain situations where, frankly, that's totally appropriate. Yeah, use that. In fact, it's better than nothing. But there are other situations when it's just really a bad idea. And I'm going to tell you now something that for any owners of healthcare facilities out there, I apologize in advance for what I'm about to say. If you take the free living will and medical power of attorney that the hospital gives you, let me just say that document was written by the attorneys of the hospital for the benefit of the hospital. And this is a little bit over the top, but it basically says, hey, if we kill you, it's because you wanted us to, and you consented to it. So don't sue us. And I'm just a little uncomfortable with that. And again, that's over the top. It's not quite that extreme, but it's appropriate for you to have documents that were written by your lawyer for your benefit that are protecting you. It's also appropriate to have documents that may extend beyond the scope of where you happen to live. These free documents that you get from state governments, or that even, frankly, a lot of lawyers, I saw this, a lawyer used the free document from the state for a client with an estate that's tens of millions of dollars. And he used the free document from the estate, and he charged money for that, which just really surprises me. And in consequence of that, by the way, that client now, the document ties the client to that state. And the client called me and said, something about this feels wrong. And I said, well, tell me about what's going on in your family. And he has children that live in more than one state. He has property in multiple states. He travels to more than one state, has businesses in more than one state. I said, so does it make sense that this particular legal document should be tied to one state? And he goes, no, that's crazy. I said, yeah, I kind of agree with that. So one of the things that we do, and this is partly a product of the fact that we deal with clients that live and work and have family members in more than one state. We represent clients all over the US. That kind of gives us a multi-state perspective. So to the maximum extent we can, we design our documents so that they'll work anywhere. They're not dependent upon any one place, and they're portable. So if you happen to live in one state today and you move to another state 3 years from now, your documents can go with you. They're not automatically made obsolete by the fact that you've moved. And to me, that's another distinction between, I don't know, a novice, a newbie, an entry-level planner, and somebody who really knows what they're doing. Somebody who really knows what they're doing, they're not going to tie you to one place. So the lawyer who they only practice in their little community. All of their clients live within a 5-mile radius of their office. They never get outside of their county. Their documents are going to be tied to that little place. And if you're in that little place and you're never going to go out of that little place, and your children are never going to go out of that little place, that might be appropriate. But if you're like a lot of other people where, wow, we live here, but our kids live over there. And we live here, but we have property over there. And we live here, but we have businesses and investment things over there. And we might move. Well, then you need documents that are going to be portable, not tied to one location, and that will work anywhere. And kind of a subtle, maybe this is an esoteric legal distinction, but something people need to know is that there are some structures that arise by virtue of a grant of license or permission from the state. And an example of that is a corporation or a limited liability company. Those are creatures of state permission. The state creates rules and says, oh, we'll recognize and acknowledge that these exist, and we give you permission to form them if you follow these rules. And to create those entities, in fact, you have to file stuff with a state government authority or they don't exist. A corporation doesn't exist if you don't file it with an appropriate state government authority. A trust or a will or a power of attorney, on the other hand, is not dependent upon state authority. You don't need permission to do it. You can just do it because you're a grown-up, because you have an inherent natural human right as a human being, as a cognitive, conscious life force to enter into contracts and to document and make decisions about your life. So trusts arise by virtue of the private right of parties to enter into contracts, not by state authority. And even though there are state laws that govern trusts or that dictate how trusts are going to work, or that might even say, well, you have to register a trust or this or that, most of those state laws are written in response to lawyers who do a sloppy or bad job in drafting trust documents. So the trust completely ignores this really important stuff. And because it ignored that important stuff, and we keep having these problems, so that it's not a question that it just has to go to the judge in a court to be decided, we're going to pass a law that says, okay, if your trust is silent on this issue, here's the provision that's going to control. So a well-crafted trust, rather than, or will, or power of attorney for that matter, rather than relying upon what the politicians tell us under the state laws, are going to spell out what's best for you and what you want. And if you have spelled it out, in most instances, that will control over what the default position, if you're under statute, says if you're silent on that matter. And this kind of comes down to a fundamental perspective or philosophy. Somebody's going to make decisions about what happens with you, your body, your health care, your property, your children. Somebody's going to make decisions about that. And there's a couple of options. You can make those decisions, or if you don't make those decisions, somebody's going to make them for you. And several people are lined up anxious and willing. The courts are there they can do it for you. And certainly politicians are willing to do that for you. Now, if we're deciding who's going to get your stuff, you will probably have a different agenda than the politicians. What do you want? Well, you want your stuff to go to your family, and you want your stuff to be a good thing for them, not a bad thing. And you want to be protected from problems that might happen in their lives. What's the politician's agenda? What do they want? Tax revenue, control, and to get reelected. So their agenda is different than yours. They're going to do different things. So this might be whatever political philosophy you want to call it, but it's take control of your own life, be responsible for your own life. You make the decisions. I think that you're going to do a better job of deciding what to do with your property and your estate and your family than someone else. So you do it. So in many respects, an estate plan is you exercising your right to make choices about what you're going to do with your stuff and your life and your family, rather than leaving those choices up to someone else who may not have your best interest at heart.
I think, Rick, for those who don't know, that is also true if you own an LLC. If you don't have an operating agreement in place, or a document that determines how your business is managed and how people leave and how people come in, then there are statutes on the books that are a default for those businesses who don't have those documents in place. So same thing, if you want to choose how your business runs and does things in the way that you want, then you should have an operating agreement that says as much. And if you don't have that in place, then the state has it in place for you.
So, yeah. And in fact, a significant point on that is many people have LLCs, just to build on that example. And they think they bought it because, having an LLC, I've protected my assets. And they go do what we call a naked LLC. They formed it at the state level, but they did no other documentation. Now, here's the default rule that's set forth in the statutes of almost every state on that. How much does that naked LLC protect you? And the answer is not at all. It can be completely clobbered. And naked LLCs get clobbered in the courts every day. They get clobbered in bankruptcy courts every day. They provide so little protection, they're virtually worthless. What they can do, they can provide some branding for a business, but they're not going to protect you. So to actually protect you, the ancillary documents that define what you want, instead of just letting the default statutory provisions control, are extremely important. And then there's other structural things like, is there more than one member? Is it member managed or manager managed? The answer to those questions matter. People think, oh no, it's all the same. It's not the same. An example my mother used to use, the ingredients for bread and cake are almost identical. But is bread and cake the same thing? No, they're different. What makes the difference? How they're put together, the order in which they're put together, and what you do with it while you're putting it together. So that the same LLC, same ingredients, one protects you, one doesn't. Same with a trust. Are all trusts the same? No way, Jose. One trust gives you certain kind of protections and another one doesn't. What makes the difference? How it's put together and what we do with it while we're putting it together. I had a family situation where a relative of mine, I won't elaborate on this because it's sensitive, but had a trust, His lawyer told him, oh, your trust is perfect. It's all you need. And the lawyer said, now listen, you don't want to put your assets in your trust. Don't deed your real estate to your trust, and don't put your business entities to your trust, because then your children will find out everything you have. Now, first of all, that was a false statement. The lawyer who said that was either through incompetence or some other motive was giving bad advice. And consequently, when that individual passed away, guess what? Their estate went through probate in more than one state. And it was ridiculously expensive. And that same lawyer who gave that really bad advice ended up charging 5 or 6 times for the probate what he charged for the trust. So he charged for a trust that should have avoided the probate, and then said, yeah, you don't need to fund it. Probate will take care of that. Don't worry. It was just wasted time and money to create the trust. I've seen that kind of advice happens in some places more than other places, partly because there are some locations, some jurisdictions that I won't mention them, but maybe they rhyme with something Sonoria, Anoria, whatever they are. But some places like that incentivize lawyers to give bad advice, because the lawyer can make more on the back end if the trust is not funded than they can if the trust is funded. So how things are put together matters. Having the documents written by someone who's acting on your behalf and structuring them for your benefit matters and makes a big difference. Let's talk about for a second here. Well, what am I going to pay for an estate plan? And I want to mention, I guess, several different levels of estate planning. There's some estates that are very small, very simple, and maybe beyond the powers of attorney and so forth. We can do a beneficiary deed, or they can have beneficiaries on their accounts. And that level of estate plan is going to be pretty modest, less than $2,000 for a married couple, maybe around $1,000 or $1,200 for a single individual if they use a lawyer. Estates that are kind of in the middle, more than small, but maybe up to $1 million, you're going to spend generally $2,500 to $3,000 in for that level of planning. We can frankly send you to lawyers. I know lawyers on a first name basis that I actually like and respect to do a very good job, who will charge twice that for the same thing we do. So you can spend more. You don't necessarily get more, but you can spend more. If you're kind of in the middle zone between $1 and $5 million, you're going to spend $3,500 to $5,000 generally. If you're more than $5 million, you're going to spend at least $5,000 and often a lot more. And if you're doing something vigorous, if you're doing asset protection, if you have a whole bunch of rental properties, if you own multiple businesses or have a medical or a dental practice of some kind, you're going to spend more. Come on, man up, pony up, deal with it. You have serious stuff going on. It's kind of like, this is a metaphor. People, they buy really nice cars. You buy a really high dollar, expensive, fancy car, and then they're not willing to put it in a garage. What? Are you kidding? Pay for indoor parking? No way. What a waste of money. So people accumulate fortunes and then they won't protect it. Kind of silly. It's good if you're out there wondering, well, who should I talk to? Talk to your advisors. Talk to your financial planner. Talk to your real estate professional. Talk to your investment advisor, your insurance advisor, if you don't know a lawyer, and talk to us. We're happy to help. We can help. Michael, do you have more questions or issues? Because I'm about to tell a final story and we can wrap this up.
Just that I completely agree with what you said about collaborating with advisors. I've seen that happen and be very effective in several different areas. And usually it's a phone call that we have with a financial advisor and a CPA, and there might be an insurance agent on the phone, and we're on the phone, and the client's on the phone with us, or maybe they're not, and we are able to collaborate and talk about issues that affect our client and we have various levels of expertise that allow for different strategies to problem solve. And when we're on the phone together and we can collaborate in that way, it's a very effective, in my opinion, to do that for the best benefit of the client. So
yeah,
I totally agree.
Yeah, your advisory team, this collection of advisors that you should have, if you don't have, you should have a lawyer, you should have a CPA, you should have a banker, you should have an insurance person, an investment person. You want your advisory team communicating with each other and knowing each other. And especially for larger, more complicated estates, my counsel is you have an annual meeting and you pull all your advisors together. It's like your annual board of directors meeting. You share notes, you turn all the cards face up so all the advisors know all the facts. If ever you get conflicting advice, for example, between a lawyer and a CPA, one of them doesn't know all the facts. If they both know all the facts, they're going to come to the same conclusion. So get your advisory team together. I also want to mention something that's kind of newish. One of the things that the recent pandemic has made more obvious is that you don't have to come to the lawyer's office to work with a lawyer. Here you are watching this video online, I assume. Today with video conferencing, it's really easy and simple to meet with people all around the country to address their estate planning issues, to consult with their advisors. We've had meetings with people where on our video conference, people are in multiple states, even multiple countries. We had one recently where the client was frankly in Africa, and there were some challenges because the internet was kind of spotty for a moment. But being local is not an issue anymore. You want expertise, not just somebody down the corner, because a lot of people aren't even willing to go to the office, even if they can. So here's my final story. Some years ago, I was working with a young, brand new financial professional. He was in financial services, just out of college, recently got his licenses, was doing investment advising and insurance planning kind of things. And frankly, he didn't have much money. He didn't have a lot of clients. And he came to me and he said, okay, Rick, I want you to show me the kind of plan that you would put in place for someone that was really wealthy. And this was back in the 80s. So we showed him a complex plan and what it would cost. And it was a lot in those days. And after he saw it, we went through it and we talked to him about the price. He said, okay, I'll take it. And I go, no, dude, no, you won't. You don't need this. You don't have anything to make this worth your while. You're way ahead of the game. Come back to me in 10 years when you've got something, then we'll do it. And he goes, no, I want it now. I said, why do you want this now? Because you don't need it. You can spend your money on something. Go buy a car. Do something else with this money besides pay us. I said, and I want the business, but I don't want to give you something that's inappropriate for your circumstance. And he said, no. He says, there's two reasons. He says, reason number one. He said, I'm going to work with clients who need this. And I can't understand their need. I cannot advise them on their need. I cannot help them with their need if I don't have what they need. So I need this plan in order to be able to help my clients. So this is part of my education. This is like another semester at college. I'm paying for this estate plan so that I can have one. I can work with it. I can deal with all the issues that arise with it so that I understand personally the mechanics, the logistics, the questions, the issues that come up, so that then I can advise my clients. Okay, that's awesome. So we did the plan and he paid for it. And then reason number two, and this is what he told me on the day he signed the documents. He said, Rick, this is awesome. He says, because here's what's happened. You've helped me create the box for a lot of wealth that I don't have yet. He says, but now that I have the box, I'm going to go fill it up. And he did. A couple of decades later, yeah, he's done really well. And by the way, he's sent a lot of people to us, and he's helped a lot of people get this level of planning that need the same level of planning. So sometimes with young entrepreneurs that come in and they say, well, what do I need? And sometimes the answer is, well, it depends. Are you going to do what you say you're going to do? Because if you're going to do that, you'll need this. If you're not going to do it, save your money. You don't need it. And we've had both kinds. We've had people say, yeah, that was just a dream. I'm not going to do that. So I'm going to save my money. And I'll just go, yeah, no, I'm going for it. I'm going to run with it. So I hope this has been helpful. It's kind of an overview of estate planning. We didn't talk about the details of wills and trusts and limited partnerships and discounted giftings and asset protection and charitable remainder trusts and all that kind of stuff. Those are technical conversations for another time, but we've talked about some of the philosophy, how estate planning relates to other kinds of planning, retirement planning and succession planning for businesses and planning your family and your property. Hopefully this has been helpful. Hopefully it's motivated you to put something on your calendar. My final advice is this: as you've listened to us, something has come into your mind, and it's been something like this: I should really do, and something has come into your mind. And it'll be different for every listener. So whatever that thing is that came into your mind, do this right now. Right now, don't delay, write it down. Write down that thing that came into your mind that you thought that you really should do. And then after you're done with this video, schedule it. Put it on your calendar to get that thing done, whatever it is. And if you do that, your time spent watching this video will have been worthwhile, and we will have done something to help make your life better and the world a better place. And that's what we all want to do. So it's a pleasure. Michael, thank you. I always enjoy doing these with you. It's great to have a co-host. And again, we thank our sponsors, the people who've promoted this and put it out there to their other listeners to view. So any final words, Michael?
I think you've said it all.
Okay. Thank you. That's us signing off.